So in the E Jean Carroll case, Donald Trump's attorneys just filed a motion for a mistrial. Don't be fooled, friends. Let's talk about it, because justice matters. Hey all, Glenn Kirshner here. So friends, day after day after day, Donald Trump's defense attorney / attack dog, Joey Tacopina, I know, continues to cross-examine Donald Trump's victim, E Jean Carroll. But maybe as an indication that Team Trump doesn't think it's going so good for them, the defense team filed a motion for a mistrial with Judge Kaplan. A mistrial. Wow. Sounds dramatic, right? It's not. And we'll talk in a minute about why it's not dramatic. But first, let's look at the new reporting. This from the New York Times. Headline, Carroll's suit against Trump continues as judge denies mistrial motion. And that article begins, the writer, E Jean Carroll's case, accusing Donald Trump of raping her in a department store dressing room, continues Monday in federal district court in Manhattan. The case against the former president, who has denied all wrongdoing, began last Tuesday and was expected to last 1 to 2 weeks. Mr. Trump's lawyers on Monday filed an unsuccessful motion for a mistrial, arguing that the court had made pervasive, unfair, and prejudicial rulings. Witch hunt? Okay, I added the witch hunt comment, but kind of sounds familiar, right? The article continues. Judge Lewis Kaplan denied a motion filed by Mr. Tacopina asking him to declare a mistrial. Among other complaints, Mr. Tacopina had argued that the judge had mischaracterized evidence to favor Ms. Carroll and improperly bolster her testimony, allowed her to note that Mr. Trump had 2 tables worth of lawyers, while prohibiting the defense from noting she had a similar number, and wrongly sustained argumentative objections to his questions. Here's what Joey Tacopina said, quote, while defendant recognizes that the court has discretion with respect to evidentiary matters, Mr. Tacopina wrote, there comes a point where the cumulative effect of its one-sided rulings manifests a deeper leaning towards one party or another. Motion denied. You know, friends, I was a prosecutor for 30 years. Do you know how many times defense attorneys made motions for a mistrial? More times than I can count. You know how often they were successful? You know how many times the case was dismissed because the judge granted the defense motion for a mistrial? Let me count it up. 3, carry the 7. 0. 0 in 30 years. Countless mistrial motions made, 0 mistrial motions granted by judges. Mistrial motions are largely frivolous. Not always, but they are more often than not completely meritless, baseless, frivolous even. So why do defense attorneys make motions for a mistrial? Because a mistrial throws the whole case out, right? Mid-trial, it's over, done. And then they have to argue over whether the prosecution or the plaintiff in a civil case gets to rebring it or not. It's a dramatic remedy. Why do defense attorneys make mistrial motions? For a few reasons. One is because in the very unlikely event that the judge gets the motion wrong and actually should have granted the motion for a mistrial because Judge Kaplan says to himself, you know what, you're right, I have been completely unfair and biased, right, in favor of E Jean Carroll, so I'm going to grant the mistrial based on my own unfairness, right? How much sense does that make? But in the unlikely event, the case gets appealed, and some appellate court judge says to himself or herself, you know, maybe there should have been a mistrial declared here. If the defense didn't make the mistrial motion at the time of trial, then he waived the right to raise that issue on appeal. He didn't preserve it. That's why defense attorneys are often making mistrial motion after mistrial motion. In the unlikely event some appellate court judge thinks maybe there should have been a mistrial, well, if you didn't make the motion, you waived your right on appeal to raise the motion. So you're preserving it for appeal. That's one reason. Another reason defense attorneys make mistrial motions is to get their opposing counsel off their game, right? Try to knock them off center. Try to make them spend long nights writing replies to bogus mistrial motions. The third reason, the reason, the Joey Tacopinas of the world might make a mistrial motion in a case like this, for the public relations value. Because what are we now sitting here talking about, and what have we seen countless stories on cable news today discussing? Donald Trump's motion for a mistrial. In the E Jean Carroll case, something must have gone desperately wrong. Nothing went wrong, and Judge Kaplan properly denied Donald Trump's motion for a mistrial. Okay, let's turn to another aspect of this story that frankly is particularly disgusting. What is Donald Trump doing while his defense attorney / attack dog, Joey Tacopina, is endlessly cross-examining a woman who the evidence suggests Donald Trump sexually assaulted and then defamed? Some accounts say that cross-examination at times is pretty demeaning and insulting. What is Donald Trump doing while this is what's going on in his assault and defamation trial? Here's what Donald Trump is doing. He posted this today. We'll be leaving for Scotland and Ireland soon in order to see and inspect my great properties there. The golf courses and hotels are among the greatest in the world. Turnberry in Aberdeen in Scotland, and Doonbeg in Ireland. We'll be meeting with many wonderful friends and cutting a ribbon for a new and spectacular second course in Aberdeen. Very exciting, despite the fact that it is Make America Great Again that is on my mind. In fact, America will be greater than ever before. That is what Donald Trump is doing, while Joey Tacopina cross-examines E Jean Carroll. You know what, friends? 2 other witnesses are going to testify. 2 other women who alleged they were sexually assaulted by Donald Trump. The jury will hear from them. The jury will also hear the Access Hollywood tape where Donald Trump announced precisely what he does, how he behaves, how he has zero regard for women. He said when you're a star, you can walk up and grab them by the pee. They let you do it. The jury will be hearing that evidence. Let me finish with this, friends. Tacopina endlessly cross-examined E Jean Carroll on the fact that as Donald Trump was attacking her, she didn't scream. So according to Tacopina, that proves that she made it up. It didn't happen. She's lying in court under oath. She's lying because she didn't scream. You know what, friends? Sometimes sexual assault victims don't scream. They are often in shock. They're scared. They're petrified. They are stunned. They're ashamed, perhaps embarrassed. And they don't scream. Sometimes they don't report it. Why? Because they don't want to have to testify about what someone did to them in a public forum with strangers watching, only to be endlessly accused by the Joey Tacopinas of the world of being liars. You know, Donald Trump might as well have said in his Access Hollywood tape, man, when you're a star, they let you do it. I walk right up. I grab them by the pee. And you know what? Most of the time, they don't even scream. Let's hope Ms. Carroll gets the justice that she so richly deserves. Because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again soon.